Appeal is allowed.
42.
Appeal is allowed.
Please, Lordship. I agree.
You heard?
J. Chetri, Lordship. J. Chetri.
Ms. J. Chetri, learned counsel for the petitioner, prays for withdrawal of the case. Hence, matter is dismissed as with.
43.
বাকিখিনি মাতি দিছ mention.
May I please, Lordship? Lordship, I beg to mention item number 16, Lordship. Kindly agenda matter 4AD.
16.
Yes, Lordship.
Item number 16 on prayer of learned counsel for the appellant. Again on.
May I please, your Lordship? With the consent of the other side, I beg to mention item number 9, Lordship. Lordship, I am appearing for the respondent number 3 and 4, Lordship. Lordship, kindly adjourn for the day, Lordship.
Prayer of learned counsel for the respondents and with the consent of the petitioner. Leave the matter again on.
Oblige, Lordship.
Please, your Lordship. With the consent of other side, I beg to mention item number 31. Lordship,
31.
31, your Lordship. Wherein we need to file our objection, your Lordship. Kindly grant with 2 weeks' time, your Lordship.
Item 31. Prayer of learned counsel for. You're for the petitioner.
I'm for the respondent, your Lordship. Please, your Lordship.
Great pleasure, Lordship. Lordship, I beg to mention item number 22, Lordship. We have taken consent from other side, Lordship.
Therefore,
I'm for the respondent, Lordship.
it.
After 2 weeks, Lordship. Bless.
What is that?
Considering the call for.
Dear TCR. CD.
Lordship.
Proceed. Oblige, Lordship.
May I please, your Lordship? Lordship, I'm appearing on behalf of DCC Fucom, and we have no objection regarding mediation.
It is submitted on behalf of both parties that the matter may be referred to mediation accordingly. Referred to the High Court Mediation Center. With the record, parties to appear before the mediation center upon receipt of notice. List again on.
Please, Lordship.
This case is my lord, respondent number one, the father of the deceased, two is the mother of the deceased. So in the cause this shows the stack of, since he is died. One is died. So showing the name of the mother. Mother name is my lord. Durga Prasad Shah. Two. No, Smita Sen. Shomita Sen.
Then two are mother and father.
A mother and father, because son died.
You are appearing for?
Respondent number 5. Insurance company, your lordship.
New India. Well, I may take this step.
You are appearing for whom?
I'm the appellant in United Insurance Company. There is a two vehicle that is.
Two vehicles. Okay, so nobody is representing the.
No, that is why, my lord, if
Claimant.
lordship shows the Smita Sen in the cause list. So I'll take the step. In this.
Was it in the original case or was it substituted subsequently?
No, it is originally we have already,
Carried.
yes, added.
Third learned counsel for the appellant and learned counsel for respondent number 5.
Fine.
This case has been listed without showing the name of any of the respondents in the cause list. Perusal of the record shows that the respondent number
1.
1, 3, and 4 have already been struck off. However, the respondent number 2, Srimati Samita Sen, who is the mother of the claimant,
Mother of the deceased.
deceased, mother of the deceased, very much present, the respondent, as is the respondent number 5, New India Assurance Company, and respondent number 6, Nirmalendu Chaudhary. Hence, list the matter again by reflecting the name of the
Number 2.
2 in the cause list.
My lord.
List again on.
Much or less.
In this case, also respondent number 1 has expired. Was the main claimant also.
So you have to substitute.
Appellant, lordship. I am for appellant.
You have to substitute the respondent number 1. Any death certificate, anything is available?
Got the instruction on today itself, lordship. I will Those documents, but
So you have to provide the court with the particulars.
not. Short date may be given.
If they have to file substitution, then they have to know the particulars.
The date may be fixed, Lordship.
Hard learned counsel for the applicant and also learned counsel for the respondent number one,
Lordship. One.
who has submitted that the respondent number one has already expired. Respondent number, the learned counsel for respondent number one, deceased respondent number one is to furnish the details regarding the death of the deceased respondent. Is the matter again on next week?
Obliged.
I'm sorry, Lordship, item number 3, Lordship. And it cannot be settled in the local mediation, Lordship, because that the case is dismissed due to lack of, Lordship, they cannot prove the disease of their son, Lordship. MSCT tribunal, the case is dismissed.
Who said? Both of you said?
My see, the peer person does not know about the facts of the case, Lordship.
So you have to inform the other side. We have passed the order in their presence.
Yes, Lordship.
Wait, please, Your Worship. I may be allowed to withdraw this bail application.
On the prayer of Mr. So there is dismissed as withdrawn.
Highly obliged.
Wait, pleases your lordship. Lordship, this is not a fit case for mediation because lordship, there was no policy issued by Oriental Insurance Company. The matter was heard and then the ICICI Lombard was made party. So I think it has to be heard. Already,
There was a dispute with regard to the policy, whether it is of them or the ICA. That cannot be decided in the, so it may be fixed for hearing.
And it counsel for the party submits that the matter is not fit for mediation. Hence is the matter for hearing. It.
I thought exactly that.
Obliged, Your Honor.
Hello, later.
Happy Your Worship.
Yes.
It's a fit case for mediation, Lordship may send it, let us try there.
Same order refer to High Court Mediation Center like previous ones.
May it please your Lordship. Lordship, we are preferring this civil revision petition under Article 227 against an order of impleadment matter. My impleadment petition was rejected. Actually, what has happened, the background of the case is that the respondent as plaintiff has filed a suit for declaration and permanent injunction. Now the respondent has arrayed one Nita Jain as defendant, and the said Nita Jain, along with my husband, is the co-purchaser of a flat. Now the suit is with regard to that flat, regarding some specific performance. But neither my husband, when he was alive, was made a party, and after his expiry also, I applied for impleadment of myself in the title suit matter, which was rejected. Now against that order, I have approached this honorable court because I am a necessary party, because if your honor turns to page, my lord, turns to page 57, that's the sale deed, my lord. Sale deed of the particular flat, wherein both the names of my husband and the said Neeta Jain is there.
Page?
Page 57, my lord. If your lordship sees in favor of
Mahinder Jain.
Mahinder Jain, that is my husband, and Neeta Jain.
Why was it rejected?
Rejected for the reason the operative portion is in page 71, starts at the last para. In the case at hand, my lord has got it. 71 page. Last para, my lord. In the case at hand, on a meaningful reading of the plaint, it transpires the suit filed by the plaintiff is essentially for enforcement of the oral agreement between the plaintiff and the defendant in respect of the suit property. Plaintiff is the respondent herein in the CRP, my lord. Whether or not the petitioner is a necessary party to the suit would depend upon the question whether the presence of the petitioner is necessary for complete and effectual adjudication of all the points of controversy arising in the suit. Admittedly, the petitioner is not a party to the oral contract between the original plaintiff and the original defendant. In the event of impediment of the petitioner as a defendant in the suit, the character of the suit would change altogether. This finding, my lord, perhaps to my limited understanding, does not reflect the correct factual position, my lord. It is not legally permissible for this court to go into the question whether the petitioner has acquired any interest over the suit property on the basis of a claim that she is the wife of the original co-purchaser of the suit property. This reasoning has been given. My lord, if the co-owner, the husband has died now, after his death, I as his wife has an equal share. And there
What is you were referring to this agreement or sale deed?
Yes.
So what is the oral agreement that is referred to in this
Oral
order?
agreement, there was according to the plaintiff, that is the respondent, the plaintiff's story, according to the plaintiff, was that the respondent entered into a oral agreement with one Neeta Jain to buy a flat. So they are coming for that specific performance of that oral agreement. The suit is for that. In the suit also.
So assuming the suit is decreed in favor of the plaintiff, your interest would be affected.
Yes, madam. Because I have a half interest is there, madam. I have a half share in that flat, madam. Being the co-owner. I have expired now. I mean, sorry, my husband is expired now. As such, I being the wife, I have approached the Honorable Court by way of that impleadment petition, which was rejected. As such, my humble prayer is that I may be allowed to be impeded in the suit. Whatever, the respondent will get a fair chance, even to adduce evidence or to reply to my allegations in the suit if I'm allowed to be impeded in that suit.
What about who is in the instance CRP, who is the respondent?
Respondent is the plaintiff in the suit, my lord.
Name is not shown.
Sujata Sethi.
Have they been served?
Yes, my lord, by the order dated 10/5/2023 has been deemed to be served, my lord. 10/5/23, man. Suit has been stayed, my lord. As such, they have constructive notice also.
It heard Mr.
A.R. Borwa.
A.R. Borwa, learned counsel for the petitioner. It appears from the record that despite service of notice, the respondent has not appeared. The petitioner is aggrieved by the order dated 08/12/2022 passed by the learned civil judge number 3 Kamrup M. Gauhati it is submitted that after the death of the petitioner's husband, he along with her son are the legal heirs, being the legal heirs of it Mahendra Kumar Jain, are necessary parties to the pending suit, and the impugned order therefore erroneous. Para. It appears that LDD's annexure page.
My lords, page 57, my lords.
Appears that a sale deed was executed on 18th December 2014 between Messrs. Akarti Construction Private Limited, 7 okay, and one Sri Mahinder Jain and number 2 Srimati Nita Jain in respect of the sale of the suit property in favor of the aforesaid persons, namely Jain and Nita Jain. Upon expiry, upon the demise of Inder Jain, her legal heirs, including the present petitioner, would prima facie step into the shoes of the deceased as far as the ownership of the suit property is concerned, and to therefore have an interest in the said property. It further appears that the present suit has been instituted by the plaintiff respondent seeking enforcement of an oral agreement between the plaintiff and defendant Nita Jain, and is the reasoning of the learned court below, while rejecting the treatment applications, that since the present petitioner is not a party to the oral agreement, her impediment would change the character of the suit altogether. It is not legally permissible for the court to go into the question whether the petitioner has acquired any interest over the suit property, the basis of her claim that she is the wife of the original co-purchaser of the suit property. The aforesaid question would arise for consideration only after the present petitioner is pleaded as a party to the suit, whereafter she can establish her right title or interest to in the suit property. Since prima facie on the basis of the aforesaid sale deed, the present petitioner has interest over the suit property, and in the event of the suit being decreed in favor of the plaintiff, her interest would naturally suffer from the present petitioner is a necessary party to the suit. Para, in view of the above, the impugned order dated 08/12/22 passed in Miss J case number 506/21 arising out of title suit number 178 of 21 pending before the court of the civil judge number 3 Kamrup M. Gauhati, set aside and the application for impediment stands allowed. The present petitioner, namely
Sudhati.
from the cause title, okay? The Jain stands impleaded as a defendant in the title suit number so and so pending before civil judge number 3 Kamrup. Petition stands disposed of accordingly.
Published.
May it please your lordship.
The Jain है ना नहीं?
भूल আছে
Lordship, a wrong file has been sent. In
No,
item
no,
number 11.
Actually, the correct file has been come, but in the code list, their files name has, number has been mentioned also. But it should be the below portion file should be there.
Anyway, the
Only in the
counsel appearing for this case is not here.
here. Lordship.
Item number 11, which has been wrongly typed. I am for the appellant in that case, lordship.
So the former case should be removed. There should be different listing.
Hmm?
Former case is not there, and that should be different from that MSc appeal. Below person,
But
correct number
this is MSc appeal 425.
423 will be there.
425 is our appeal, lordship. The HDFC versus Forest Money.
Yes, Lordship.
That file is not-
423 has come actually, but it is this tag is of 425.
Yes, Lordship.
That is why the problem is arising.
This 423 is there today itself, but 425 should be
File is
listed in the other day. That file is not here, Lordship. In the mistake is there only code list only, Lordship.
7, it appears that although the appeal 425 of 2025 has been shown against the said item number in the cause list, the record of C appeal 423 of 25 that has been placed before the court. It also appears that the record before the court has been wrongly.
So record is, two cases record has come, Lordship. But the former case record
Wrongly
is not
tagged
there.
as MSc appeal 42525.
Correctly listed.
listed
In
separately.
the sticker. Sticker on top of the cover page. Okay. Hence. You are in 423 or 425?
425, lordship.
Hence, necessary corrections be made and MSc appeal 425 of 2025 be listed again with the correct record on it. This sticker here, it is 425. That is why this has come wrongly marked.
423 record is evident.
But this 423 may kindly be taken, Lordship. Here.
23, no?
4 to 3 we can we take up today? No, it is not in the list.
Well,
The entire record is here, Lordship.
But we can have it listed tomorrow or whatever, but we cannot take it up
Right.
unless it is there in the list.
in 425, my name is Ravindra Chandra Pal. It may be Mala RC Pal because when I
Add a line. So the name of learned counsel appearing for respondent
appellate
for the appellant as Mr.
RC Pal
RC
instead of
Pal.
Ravindra Chandra Pal.
Instead of
Ravindra Chandra Pal in the call list.
or Govinda Chandra Pal in the cause list.
So it is difficulties when I'm going through my mobile, but it not. So today also I have not brought this record because my name is always written as RC Paul.
Well, okay. This is 11 you are talking about.
Today I also missing, but I could not brought this. My file.
IA. Acha, IA, in the IA.
Yes,
Instead of Ravindra Chandra Pal.
list.
As tomorrow it may can be listed. 4 to 3 can be listed.
Not
tomorrow.
tomorrow I may be listed.
May not be. Let it come on miscellaneous day, Friday.
Well,
Mondays are 23rd.
All right, Monday.
23rd Monday.
much of it.
4 to 3 may kindly be listed. 4.
May I click your
বেলেগকে তাহলে মেনশন মেমো দিব লাগিব এইটো নাহা কেছটো list MSc appeal 4 to 3 of 25. 3rd. Yes.
Wait for some time,
Item 12.
Lordship.
What is the meaning of some time? Passover for the time being, for the day, for the month?
A week of the file, Lordship.
Prayer of learned counsel for the petitioner is the matter again on.
Yes.
Please, Your Worship. Appeal against an order passed by the Motor Accident Claims Tribunal Dhemaji dated 1st of March 2025, whereby I, being the owner of the vehicle, was directed to pay the compensation. Now, in the written statement, my lord,
The compensation amount is only, my lord, 8,550, my lord. That's what to consider, my lord. 8,000, my lord.
I'm under instructions.
How much did he pay you?
My lord,
Even I am
8,000
not-
rupees, my lord. Now this appeals come before your lordship. my lord.
I understand, my lord, but I'm under instructions. Now, the only aspect is in the written statement, I have taken the categorical stand that I have sold the vehicle. And after that, the person who have sold it to had sold it to a third person who was made a party. He was the driver. Now, I being the previous owner, I was directed to pay the compensation, not the driver. Because the vehicle was not insured and the driver also didn't have a license. That was absolutely not taken into consideration or discussed in the judgment.
So what is wrong with the order?
My lord, if your
There is
lordship,
no license. You allowed your driver without a license to drive.
my lord, I was the previous owner. I have been added as a party owner.
Huh.
However,
So where is the,
My
did you
lord,
lead evidence to show that?
yes, my lord, my lord, in my written statement.
At the
which-
time of the accident, you were not the owner, that the transfer had taken place prior to that.
My lord,
What do you have
gave
to
that
show?
in the written statement. It's there in the written statement, my lord, that it starts at page 17 and the relevant portion is at page 18, first paragraph. Page 18, first paragraph. I sold it to one Joydul Islam and he then sold it to the driver, Mon Bahadur Dorji. He's the new owner.
What is the date of sale?
Uh, the sale deed was, and I have not annexed the
Sale deed
deed.
is no good. Where is the registration certificate?
That was not done.
Then
I admit, ma'am, that was not done.
anybody can make a sale deed with somebody and show it.
But-
I am not the owner.
but
Unless
this is the-
registration is transferred.
Still he is the owner. At that
Officially,
time of-
yes, my lord, going by the DTO's record, my name will crop up, my lord. However, this entire issue was not discussed at all. It was not even taken into consideration.
8,000 rupees, my lord. Now before your lordship.
Okay, we are the first appellate court. We can take it into consideration. You have nothing to show that you have sold it except a so-called sale deed. On this point is clear, unless the registration is transferred, you continue to remain the owner and liable. Third, learned counsel for the petition appellant and learned counsel for the respondent insurance company. Anybody appearing?
It's just not, my lord. I'm the claimant. Respondent one, my lord.
Respondent number 1. Whether 2 has been served.
Yes, my lord, there was a delay coordination petition and it was, the delay was allowed after service.
None appears for respondent number 2. Service of notice in the connected delay application petition. A condonation petition. Go to paragraph 1 of the appeal. This appeal is directed against the judgment and award dated
1 3
First of March 25.
March 2025, passed by the learned member MSCT Dhemaji in MSC case number 15 of 22, awarding a compensation of rupees 8534 to the claimant, payable by the present appellant who was the owner of the pending vehicle. To para 2, page 30, para 2. 2, 3, 4. Upon examination of the witnesses and after considering the evidence on record, the learned tribunal came to the finding that the payment was entitled to a total compensation of rupees 8,534. And further, that it is the owner of the offending vehicle bearing registration number AR01C7527 within bracket Tata Sumo, that is the present appellant, who is liable to pay the aforesaid compensation. This finding was based on the fact that at the time of the incident, the vehicle was being driven by the driver, the owner, who was not having a valid driving license, and therefore, and as further, since the vehicle was not insured, is the owner of the vehicle who is liable to pay the compensation. And there is no dispute with the aforesaid proposition. However, the appellant claims that he had already sold the vehicle to one. Where is the deed?
Deed is not there, madam. My statement, para 18, page 18.
Page 18. But you submitted the deed before the trial court.
Yes, madam. Yes, madam. The records will reveal, madam. Not annexed in the appeal, but the LC, it will be in the LCA.
LCR is here.
No,
So you have to say when you sold it. What you say reveal? It is your case. Where is your WS?
page
18.
18.
Name of the appellant, cancel that first line. They sold it. Huh? Then after note with the proposition, then you start. Okay. The stand of the appellant that is no more the legal owner of the offending vehicle, as he had sold it to one Joydul Islam, a resident of Borpeta in Assam, presently residing in Itanagar, Arunachal Pradesh. Again, the same has been purchased by one Mon Bahadur Dorji from the said Joydul Islam. And as such, the present appellant is not liable to pay the compensation. The aforesaid stand was taken in the written statement submitted by the present appellant as respondent number 2 before the learned tribunal. No date of sale is mentioned. The aforesaid written statement so as to show whether the said sale took place before or after the event. Furthermore, it is an admitted position that the registration of the vehicle still stands in the name of the present appellant. Effect, that has been pointed out by learned counsel for the insurance company. Full stop. That being the case, the appellant stroke owner cannot escape liability. The basis of a sale deed, so-called sale deed. Full stop. Give up the above, this appeal is devoid of merit and stands dismissed.
Appeal.
Appeal will be heard. So this appeal is preferred by the claimant for enhancement of compensation lordship. So appeal may kindly be admitted and the notice LCR may kindly be called.
If it is enhancement, why don't you go for mediation?
No, lordship, this is to be admitted first, then notice will go.
But who is appearing?
I'm for the insurance company. That is what I was telling him, Lordship. It can go to Lok Adalat also.
No, lordship, after admission, we will go for local. Just,
Lok Adalat is coming.
yes, we'll mention it in
Heard
the
learned counsel for the appellant. So heard learned counsel appearing for respondent number 1. To notice 2. How many respondents are there?
I have
total 3 respondents.
Respondents number 2 and 3. Who are owner and driver?
Owner driver.
2 and 3. Steps by registered post with AD.
No, the registered post is not the speed post lordship.
Speed post, all right. Speed post AD. Within 3 days.
1 week lordship, my kindly. 1 week lordship.
Why do you need 1 week for this? When is a local alert?
14/3 lordship.
Yes, take steps immediately. It may come back. Where is the address?
It is in quantum lordship. They are not necessary as such.
Yes.
The lordship is sending because it is formal.
Owner driver.
Indemnify no kore no. Not যাও কিন্তু
Place the matter before the upcoming local alert on 14/3.
copy may be given to us so that I
LCR
can
required
give it.
lordship. LCR has not come, so the LCR called for first.
Right, also call for the LCR.
Local next date will mention for local. Because without LCR lordship, it is not possible to settle. Because the
So
documents
we'll give a date before 14 then.
then before 14 lordship, yes.
Give a local alert party you cut. List the matter again on 11th March.
LCR may call you for.
Call for the
Copy may be given to us so that I can give it
We'll
to
give
for
copy lordship.
settlement.
We'll give for copy.
Hello, bless.
কিমান হল? None appears on call. Is the matter again on?
My lord, this case may be sent for mediation. My lord. No problem.
Lordship, we have no objection.
Submitted by learned counsel for sides that the matter may be referred to mediation accordingly. Referred to High Court Mediation Center. Parties to appear before the mediation center upon receipt of notice.
Pledged.
Again.
My choice.
Please, your lordship. Can it be possible for timing, my lord? Take it up at 2, my lord, because my senior SP he's on legs, my lord, in the phone. Much. Wait, please. The last occasion, my lord, with your lordship's permission, my lord, I've gone through the PCR, my lord. My lord, somehow, my lord, something happened, my lord. After going through the TCR, my lord, I found, my lord, that 47 notice is also not complied with, my lord. There is no acknowledgement on behalf of the, my lord, the petitioner, my lord, the accused.
That your petition doesn't say so.
No, my lord. Actually, after going through the report, my lord, I found.
You should have filed an additional affidavit. Yes, PP.
Lordship, before it, Lordship, may kindly, I have, on last occasion, I raised my objection regarding that, Lordship, whether this petition is maintainable or not, Lordship. Because, Lordship, already, Lordship has twice, Lordship has rejected the bail application of this petitioner, Lordship. And while rejecting the same, on the same ground, whether again, it can be reiterated or not, Lordship. Because, Lordship, 403, section 403 BNSS parts that, Lordship. First, that may be decided, and thereafter, Lordship may can report. Because, Lordship, earlier, Lordship has observed, Lordship has decided the entire thing, Lordship. 47, Lordship has clearly, Lordship has observed that part also, Lordship, regarding 47 notice, Lordship, that has been furnished. That part is also there in the first judgment, Lordship, order, Lordship. Subsequently, again, it was rejected on that ground, Lordship, that there is no any, already that issues has been discussed. So this petition is not maintainable. On that regarding on that issue, that second petition has been rejected. Now again, third petition on the same ground, Lordship. Section 403 specifically verse. Lordship, may kindly come to page 43 of the petition, Lordship. Para 8. A perusal of the record would show that section 47 of BNSS has been duly complied with as far as providing the of information regarding the ground of arrest to the accused persons in writing is concerned. And more so, also, apart from this also, in earlier occasion, they have twice they have raised that to file their application regarding 48 notices, Lordship. But they did not stated that 47, what about 47? There is no any mention, Lordship. When and even, Lordship, whether they are prejudiced, that part Lordship has discussed in Lordship's first order, Lordship, whether they are demonstratively prejudiced, Lordship. Because, Lordship, immediately after third day of his arrest, he and the counsel for the petitioner has filed Bakaratnama petition for the trial court. So Lordship, they are not prejudiced, Lordship. They knew that why he has been arrested, everything is Lordship. Dear Lordship. Demonstrable prejudice part is also come, but that will come later on, Lordship. Prior to that, Lordship, whether this petition is maintainable or not, Lordship. But maybe.
Yes,
My lord, in this case, my lord, page 43, my lord, the page which is relying, my lord. Paragraph 7, my lord. Lordship has find, my lord. Paragraph 7, my lord. Par contrast, the learned additional public prosecutor has submitted that the petitioner have been fully aware of the grounds of the arrest as would be apparent from the notice under section 47. Well, it's a wrong statement, my lord. It's misleaded the court, my lord. Because 47, when I gone through the record, my lord, it was not there, my lord.
that was the duty of the council to point out.
My lord, actually, my lord, I have not gone through the record, my lord. But to be honest, my lord, I am not blaming anyone, my lord. My lord, not the PP or my other counsel who appeared before, my lord. But the fact remains, my lord, that the 47 is not served, my lord.
Even after that submission, wrong
Yeah.
submission, Lordship.
No, wrong submission.
Even after that,
I
submission,
have-
Lordship, in second application, they have again filed one petition.
Yes,
Lordship.
my lord, that's
In
true,
that
my lord.
petition, they did not raise that
Yes,
petition.
that's
they
true, my
appealed,
lord.
Lordship.
The fact remains, my lord, the section 47 is not complied with, my lord. On the end of the day, my lord, that remains, my lord, the 47 is not complied with.
The question is whether we can revisit after we have recorded a finding.
Then your lordship, my lord, kindly allow me some days, my lord, I'll file a additional affidavit, my
All
lord.
right.
In that
On the
case,
prayer of
but
learned
because-
counsel for the
May submit,
learned.
may submit, Lordship.
My lord, can
That issue has already been, if they can file a petition.
If they want to file an additional affidavit, what is the difficulty? Let them file.
my lord, can it be on, my lord, Monday, my lord?
All right.
23rd, my lord. Yeah, additional affidavit, my lord.
But Monday, I don't think I'll be available.
My lord,
Can't be taken up by anybody else in my absence.
no, my lord, it's a rejected bill, my lord, your lordship has to take.
Sometime later in the week, then.
Later in the week.
The prayer of Mr. So and so. Mr. Again also has to enable him to file additional affidavit.
Please, your lordship. Lordship, this IAS file for correction of order dated 5/2/25. 48, your lordship.
Yes, what is the correction required?
Paragraph number 9, page number 9, your lordship. Alaka magistrate has been mentioned. It ought to have been a special judge.
And this IA has been preferred seeking correction of the order dated 5/2/26. Passed in bail application 78 of 2026, wherein at paragraph 9, it has been stated within quote to the satisfaction of the learned Elaka magistrate, unquote. Where it is stated that the case is pending before the learned special
Special
judge
judge Kachar.
Kasar CPS, and hence the aforesaid order requires correction. So having regard to the above, the aforesaid words within quote Laka magistrate quote, shall stand corrected as special judge. Achar. This order shall be read as part of the order dated 05/02/26. I stands disposed of accordingly.
Deeply obliged.
Due to some personal incapacity, Lordship, the arguing counsel is unable to appear. Kindly pass over the matter for the Lord.
Item 15.
15, Lordship. 1
On
5.
the prayer made on behalf of learned counsel for the appellant, lays the matter again on
After 1 week, Lordship. Nice, Lordship. Please, your Lordship. Appearing. Lordship, I am appearing for the petitioner. My senior is on legs. So what the matter that I make. All of this of nothing. It's name.
May please your lordship. As per office note, LCR has not come, lordship.
learned counsel for the petitioner, appellant. It appears from the office note that despite repeated reminders, the LCR has not been received from the MACT Kamrup M. Gauhati. An old pending matter of the year 2012. The MACT Gauhati directed to submit an explanation as to why the LCR has not been transmitted till date. By the next date fixed. Is the matter again on. And so registry is directed to communicate a copy of this order to the learned member MACT Gauhati.
Oblige, Your Honor.
This sent to mediation, earlier sent to mediation, my lord. This matter may be sent to Lok Adalat settlement, my lord. Incoming Lok Adalat. 13 March, my lord.
What happened in mediation? Nothing.
Nothing, my lord. They have not come, I think, my lord.
Who is the appellant here? Insurance company.
I am in for insurance, my lord. We are ready for settlement in Lok Adalat, coming Lok Adalat. Name has been thrown, my lord.
If party is not present, what is the point of referring to Lok Adalat?
Fix a date. Next. Any date may fix for Their patents also, ma'am.
Name is also not shown.
UJ Sekia and A Gohai, my lord. UJ Sekia and A Gohai.
Item, this is item
Item 19, my
19.
lord.
Counsel for appellant is present, however, none appears for the respondent, although name is shown in the cause list. Then for pending matter, the year 2016. The event of list the matter again on so and so. The event of non-appearance of the respondent on the next date, the matter will be proceeded with in their absence.
Placement. Placement.
None appears for the appellants on call. It is reflected in the previous order dated 05/05/25 that appellants have not taken steps upon the respondents despite sufficient opportunity. One more opportunity was granted. Take steps upon the respondents. As per office note dated 6/3/25, steps have been taken by the appellant. View of the appeal dismissed for non.
May I please, your lordship? Your lordship, as per mediation report dated 19/12/25, the mediation has failed. So it may be listed for hearing.
Had learned counsel for the appellant. As per communication dated 19/12/25 from the mediator to the secretary, High Court Mediation Center, have made the parties failed to arrive at a settlement and mediation has failed. Hence, list the matter for hearing.
Obliged. May I please, your lordship? Lordship, please, some time may be granted so that we shall take steps upon respondent number 2, as well as we shall also file a substitution petition.
You have to file delay condonation also with substitution. Filed 8 years ago. Learned counsel for the appellant prays for some more time to take steps upon the respondent number. Tracing out the proper address. Appellant is directed to obtain the proper address of the respondent number 2 and take steps by speed post with AD. 7 days. Is the matter again?
In item 24, my lord, we have to implead the legal heirs of respondent number 1, my lord. My colleague has misplaced, my lord. They have again give us the name of legal heirs of respondent number 1. Then, my lord, so some time may be needed, my lord.
Once we had provided, lordship.
Prayer of learned counsel for the appellant list the matter 1 week on.
God bless you.
God bless.
May it please your lordship. Here, lordship, service is complete upon respondent 1, but so far as the respondent 2 is concerned, your lordship will have to confirm whether service is complete upon them or not. Because in the last order, we have stated that service is complete. So kindly give us 1 week time, your lordship.
Appellant is
Lordship, I am appearing on behalf of Mr. S.P. Choudhury for claimant.
number 1 is arrest. ID card and service report of respondent number 2 has not been received back. Dated. As per office note dated 20/08/25, steps has not been taken for issuance of notice. And then number however, it is reflected in the order dated 22/08/5 that by learned counsel for the appellant that notice upon the respondent number 2 has been served personally. If it is served personally, what proof do you have?
Your lordship, regarding that, we are seeking 1 week time.
For appellant place for some time to obtain proper the matter again on.
Much obliged.
Please your lordship. In this case, I'm appealing for R. Goswami lordship for the appellant, and as per last order, the appellant was directed to take steps on respondent number 5 through Dusty's lordship. And we have taken the step that there is a report from the investigator that respondent file could not be traced down, Lordship. So his name may be struck off. He is the driver, Lordship.
Submitted on behalf of the appellant that although attempt was made to effect service by way of Dusty, the appellant, the said respondent number 5 could not be traced as per report of the investigator. Order prayed on behalf of the appellant that the name of the respondent number 5, who is the
Driver, Lordship.
driver of the vehicle, be struck off. Accordingly, the name of respondent number 5 be struck off.
I am appearing for the appellant, respondent 1 and 2. I am the claimant actually. And she is lady, wife of the. My prayer is that she is ailing also, and the respondent 2 is a daughter, pursuing studies. So matter may kindly be heard finally, month of March, and I have also
LCR trial court report has not received, Lordship. That may be called for and matter may fix for hearing, Lordship, after receiving the trial court.
Since I picked the respondent number 1 and 2.
1 and
Here is he received call for the TCR. The matter again on
Online, Lordship.
May please, your lordship.
There is the mediation report, otherwise settle.
settle.
Not settle.
Lordship. Learned counsel for the petitioner and appellant and respondent are present.
120.
As per mediator's report, the mediation has failed. Hence, here is received.
Answer is listen.
Here has been received.
May please, your lordship. Lordship, I am praying for press step for regarding respondent number 7 and 8, owner and driver. Lordship.
All are not served.
Not sir, lordship.
Without service, it was referred to mediation. Appellant to take fresh steps on respondents number 7 and 8 by speed post with AD. The matter again on
Online, sir.
May it please your lordship. My lord, in this matter, my lord, earlier it was sent for mediation, my lord, but because of some communication issues, my lord, the parties did not appear. So it may be again sent back to mediation, my lord. Or the local Adalat, if possible, my lord.
learned counsel for the petitioner, none case for the respondent as per of mediator. The patient could not proceed as the As no response was found from both the parties. It is submitted by learned for the that appellant that communication gap, the parties could not be informed regarding the mediation taken place earlier. Submitted that the matter be referred to mediation. So that what will you do? Who will inform?
Will inform, my lord. Will inform the other side.
About the appearance of the parties. Last time parties did not even appear.
Yes.
So what is the guarantee they will appear again?
Sir, in fact, my lord, in this matter, from the beginning, the respondents have not appeared.
Time also mediation will be waste of time, I think.
Lordship may pass a direction to the.
You may bring your party, we will
Yes.
bring their party.
The effect that we will take the necessary steps for informing the other side. Oriental insurance.
You first inform and then we'll refer.
My lord.
However, due to absence of learned counsel for the respondent, for the appellant takes to inform learned to appear on the next date. The matter again on.
Hello.
No, due to oversight, my lord, we have not taken, filed affidavit for dusty service on respondent number 3 and 4, my lord. So some time is needed, my lord.
Counsel for the petitioner and learned counsel appearing for respondent number.
One, Lordship. Two is already struck off, died. Respondent number one, claiming Lordship. Struck off.
Eh?
Respondent number two is struck off.
And number 2 has already been struck off. So for the appellant, space for further time to file affidavit regard to dusty service on respondents number 3 and 4. Last time also you were given 3 weeks time. So this time we are going to give you 3 days time.
Yes.
Is the matter again on Friday.
Please.
Please, Your Lordship. I need to take steps. This IA 2323 is for condonation of delay. And service is not complete. I was supposed to take steps, but I couldn't because I couldn't contact the applicant. So another chance may be given. Respondent number 1, 2, 2, 4, 7 and 8 and 6 needs to be substituted.
The prayer of learned counsel for the appellants list the matter again on and shall take steps accordingly pursuant to order dated 12/2/25.
Obliged.
Yes, please, your lordship. I may be allowed to take steps, lordship. We have not taken step. And in this case, there was a typographical error in cost title and prayer, lordship. And in order dated 19/2/24 in the title suit, we file IA for correction and correction has been done.
So IA is already disposed of.
Yes, lordship.
For 1 year, you have not taken steps
Yes, lordship. Kindly last.
and you are enjoying a stay order.
Last chance may be given, lordship.
But learned counsel for the petitioner hears that the learned that the appellant has failed to take steps for 1 year pursuant to order dated 19/2/2024. Petitioner is granted. Appellant is petitioner is granted 3 days time to take steps by registered post ID, failing which the interim order of stay shall stand automatically vacated. Is the matter again on Monday.
May it please your lordship. Your lordship, in this matter, LCR hasn't been received. Otherwise, service is complete.
See what is the problem, why LCR has not been received by the central division. With date.
Much obliged.
Please, your lordship. Lordship, I am appearing for the appellant in this case. The matter has already been admitted and service has also been completed upon both the respondent. But even after receipt of notice, they have not appeared, lordship. Kindly, short date may be fixed for hearing. Lordship, in this case, we have also filed our affidavit cum declaration showing postal track consignment report.
This is a Gauhati address. You could have taken dusty service. Hard learned counsel for the appellant. PCR has been received. Appellant has submitted an affidavit along with track consignment report showing service of is the respondent number 2, 1 and 2. 2 on 11/9/2025. Insurance company is respondent number, but as per the postal endorsement, no longer available at that address.
Chief, we have served our notice 2 times.
When you say served, they are not available at their address. How can you serve them?
But in the postal track consignment, it has been written as delivered, lordship.
The postal notice dated 13/6/25 says addressee left from this address. Then how can track consignment say it was delivered on 11/9/25? Took steps on the same address. There is no change of address, is there?
We will take fresh steps, Lordship.
Find out the address first. Present address. It's a company, should not be difficult.
Yes, Lordship. Universal phone book.
দিছিলো নেকি ডিটেকশন হলো? For track consignment. However, the postal endorsement shows that postal endorsement dated 13/6/25 shows that the addressee Universal General Insurance Company Limited had left the address. Petitioner is appellant is directed to take fresh steps upon both the respondents by speed post AD after ascertaining proper address. Directed to take steps by way of dusty service. The matter again on
I do oblige, Lordship.
My Lord, I have filed this IA for substituting Lordship the legal representative of the respondent number 1, Lordship. So I have annexed an order, Lordship, where I have come to know that the respondent number 1's representative has expired. Immediately I have filed this application, Lordship.
But we have no objection.
My prayer is at 17, page 17, Lordship. One seven, Lordship.
this IA. For seeking substitution. The respondent number 8. Mojibar Rahman. Bill, page 7. Who is the deceased? Nazrul Islam.
Nazrul Islam, Lordship.
Number 1. Nawab Nazrul Islam.
He is representative, Lordship, of the respondent number 1. Organization. Respondent number 1 is the organization, Lordship.
As the representative the number 1 organization. Sir Rahman. Bill. W.
Lordship, he is also personal party, respondent number 3, Lordship. Private party is also there. He was.
That the said Sir Rahman already a party respondent as the respondent number 3. Party's capacity.
No, Lordship, sorry,
It
Lordship.
is?
The Mujibur Rahman is party respondent number 8, Lordship, and the earlier representative was respondent number 3, Lordship. He was as a private party was also there, he was, and representative of the party respondent number 1 also was there. He was there.
He was earlier responding, he was the one who is to substitute the deceased. He is already respondent.
Respondent number 8, Lordship.
Who is 3 then?
Three was, Lordship, the earlier one.
Nazmul Haq.
Nazmul Haq, Lordship. Nawab Nazrul Islam.
ठीक है. You are for respondent? But the respondent says no. Accordingly, the name of Mahibar Rahman bill is instituted case of Bab Nazrul Islam. As respondent number?
As the
Representative of respondent number 1.
Respondent number 1.
And now respondent number 3 may be struck off because since expired.
Further, in view of his demise, the name of respondent number 3 be struck off. The application we filed for amendment of the first title.
Lordship. And Lordship, one prayer, Lordship, in main case, Lordship, registry may be directed to correct in the system because in the appellant is one organization and represented by Sri Matiur Rahman.
He is also directed to make approach and apprise.
Lordship. Lordship. In main case, Lordship, a date may be fixed if Lordship possible.
My lord, because the matter was posted for hearing.
After 3 weeks, Lordship, any date.
That may be fixed on maybe.
Lordship.
Deeply
Deeply obliged.
Disposed of. In appeal, please that this appeal for
Obliged, my lord.
the prayer of learned counsel for
Please, your lord. But by way of this IA that I have filed, I have, my lord, prayed for slight modification of the order dated 22/10/2025, which was passed by this honorable court, wherein there were certain directions for effectuating service of notice upon some of the respondents after the notices came back with certain remarks. Now, my lord, if your lordship kindly takes up my petition for a while, your lordship will kindly take up, my lord, my petition from starting from page number 10, paragraph number 3. This is the actual position from paragraph number 3, page 10, my lord. If your lordship, my lord, just allows me to point out specifically. So far, respondent number 6 was concerned. The postal remark that came after we took steps for the first occasion, it came that respondent number 6 now resides in New Delhi, and there was a direction from this honorable court on the previous occasion for us to take steps upon respondent number 6 in his present address. Now, we ascertained that he is not in New Delhi. He is very much out there in the address that was provided earlier. Now, we are praying that in regard to respondent number 6, we will be allowed to take steps by Dasti because we will be able to serve him by Dasti. That is insofar as respondent number 6 is concerned. Now, insofar as respondent number 10 is concerned, my lord, here the remark that came on the previous occasion, which was recorded by this honorable court on the last order, was that no such person was found in the given address. Now, insofar as our instructions, my lord, goes, respondent number 10, the address that was provided to us, that was the last known address. Now, respondent number 10 was the pro forma defendant in the suit who did not contest the suit. And her siblings are already respondents number 7, 8, 9 in this revision petition who have already been served with the notice. So I pray for respondent number 10, the service of notice, the issue notice may be dispensed with in regard to respondent number 10, my lord. And my lord, in regard to two other respondents, that is respondents number 11 and 12, the report.
Dispense with means what? We treat it as complete.
No, the requirement of effectuating service upon respondent number 10 may be dispensed with.
Then he has to be struck off.
My lord, that can be, because she was a non-contesting pro forma defendant in the suit. And insofar as respondents number 11 and 12 are concerned, the remark came that they expired. Now, insofar as respondent number 11 is concerned, my lord, here in this IA, I have, my lord, pointed out that actually respondent number 11 is a bigraha. It is a religious institution. Now, the person who expired was the representative of the Vigraha. So he only needs the present Sebayat of the Vigraha needs to be incorporated in place of the earlier one who has expired. So to that extent, my lord, there is a prayer. And insofar as respondent number 12 is concerned, my lord, who expired and we were asked to take necessary steps for substitution, I have categorically stated in paragraph 8 of my petition that her legal heirs are already on record as respondents number 13, 14 and 15 in this petition who are already served. So these are the positions, my lord, that I my lord, sought to apprise this on.
So let us start with
6.
others being served
Yes,
already.
7, 8, 9, 13 and 13, 14 and 15 were served. And 1 to 5 are
Learned
represented.
counsel for the petitioner and also learned counsel appearing for respondent numbers 1 to 5. Respondents number who have been served
My lord, 7, 8, 9, 13, 14 and 15.
have already been served. Yes, with regard to respondent number 6, it is submitted that although it was earlier directed that steps be taken on the said respondent at Delhi, has come to the knowledge of the petitioner that respondent number 6 is very much residing in the present address. Accordingly, prays for effecting dusty service. Prayer is allowed. Then come to 10.
10.
What was 10?
10, my lord, no such person found in that address. So I pray
As
for
far
that.
as respondent number 10 is concerned, it submitted that the said name may be struck off. Accordingly, name of respondent struck off. Then 11 and 12.
11, my lord, first. 11 is the Vigraha. The
Respondent number 11 is the Vigraha of the
my lord, Radha Madhav Jew Vigraha is the respondent number 11, represented by earlier Sebayat who expired. Now I pray for only incorporating the name of the present Sebayat.
respondent number 11 was the Sebayat.
It was the Vigraha represented by the Sebayat. Now that Sebayat
11
expired.
was the Vigraha who was represented by the Sebayat who has expired. Accordingly, petition has been filed already.
My lord, I have given the details of the present Sebayat in paragraph number 7. I want the name to only to be my lord, input.
In his place, the present Sebayat the details of whom has been incorporated at paragraph 7. The present application is required to be substituted. Prayer is allowed. Then 12.
12, the legal heirs are already on record as respondents number 13, 14 and 15 and they are also served.
The legal heirs of respondent number 12 who has also expired already record and have been served. What needs to be done now? Only the dusty service on respondent number
Dusty
6
service
remains.
we will take within a week, madam.
Necessary corrections be made in the cost title. Is the matter again on?
Deeply obliged, madam.
May please, your lordship, my lord. In this case, my lord, notice is required to be issued to the opposite party, my lord, in the interlocutory application, my lord, present interlocutory application. Opposite party
Senior
number 1
counsel
and 2.
appearing for the applicant. Is on the respondent's number
1 and 2.
1 and 2 steps by speed post AD within 7 days. Is taken on.
Published, my lord.
Please, your lordship. If we have filed this I 433 of 2026 to because respondent number 4, 5, and 6 have left their address, lordship, and they have shifted to Pune. This I is filed to ensure the new address, lordship, and accordingly takes steps on 4, 5, and 6. However, lordship, respondent number 7's address is intact. We may be directed to take fresh steps on respondent number 7 also, lord.
Others you have taken already.
Yes, lordship.
Learned. Our learned counsel for the and learned counsel appearing for
Respondent number 1, 2, 3, 8, 9, and 10. Shi Sharma.
is directed to take fresh steps on respondent number
4, 5, and 6 on the new address and 7 on the
4,
previous.
5, and 6 at the new address and 7
on the present.
and also respondent number speed post AD within 7 days list again.
Vice lordship.
For hearing.
May I please, your lordship? That impugn order, my lord, at Annexer F, page 32, that what happened, my lord, the suit decreed, my lord, first appeal preferred dismissed, second appeal preferred dismissed, thereafter execution started, my lord. In execution stage, there is a report from Ratmandal that cannot be identified. And, my lord, because that the suit plaint was, my lord, the schedule of the plaint as per the cell deed of 75. That's why, my lord, a petition has been filed under section 125 and 152 and 153 capital A for correction of that boundary. That was rejected. And this is, my lord, annexure of my lord, impugn order.
Yes.
My lord, I'm reading. That order arises out of petition number so and so under section 152 read with section 53 ACPC filed by the decree holder, whereby it is submitted that title suit 30/2011 filed by him was decreed in his favor on 18/8/12. That first appeal bearing title appeal 25/12 was dismissed on contest. That RSA number 113/2014 was also dismissed by the order dated 25/8/2014. That in instant execution case filed for execution of the decree passed in title suit 30/2011, the possessory warrant could not be executed by the bailiff of this court as the four boundaries appearing in the decree did not tally with the present boundaries of the suit land. The plaintiff has mentioned the four boundaries in the plaint as per the deed of sale through which he purchased the suit land. That in the meantime he has collected the exact boundaries of the suit land which mentioned in the schedule of the petition. That the identity of the suit land has never been disputed by the defendant throughout the proceeding from original court up to the second appellate court, situated thus, taking into consideration that a decree of competent court should not be allowed to be defeated so far as practicable for the accidental slip, prayer has been made to allow the decree holder to amend the decree with regard to the four boundaries of the suit land. Opposite party judgment debtor filed written objection denying and challenging inter alia claim of decree holder and stated that the petition is filed with a malafide intention is a result of his willful deliberate concealment of real fact of the case, that the insertion of wrong schedule four boundaries of suit land by the decree holder is in petition for execution of proceeding as well as plain of the original title suit. It was absolutely intentional. That the original record of this said title suit along with the concerned jamabandi of the suit land itself speak the truth. That the proposed amendment as preferred by the decree holder does not stand fit as this juncture of the proceeding and in the manner as preferred, as the amendment goes straight to the root of the case and has a direct bearing of the nature of the suit, situated thus, prayer has been made for dismissal of this petition. Opposite party, in support of his case, relied on the judgment reported AR so-and-so, Dwarka Das versus State of Madhya Pradesh and another, wherein it is held that Section 152 CPC provided for correction of clerical arithmetical mistake in the judgment, decree and order errors arising wherein from any accidental slip or omission. After passing the judgment, decree and order, court tribunal become functus officio and thus not entitled to vary the terms of judgment, decree and order passed earlier. The correction contemplated are the correcting only accidental omission or mistake and not the all omission of mistake which might have been omitted by the court while passing the judgment or decree. The omission sought to be correct with the goes to the merit of the case is beyond the scope of 153, of which proper remedy for aggrieved party is to file appeal or review application. And also seen the petition number so and so filed by judgment debtor with the prayer to dismiss the execution proceeding on the ground that court personnel failed to identify the suit land due to wrong schedule. I have already heard learned counsel both the parties peruse the available material on record. As per the prayer made by the learned counsel both the parties, the record of title suit number so and so has also been called for perusal of the schedule of the plan. It is revealed that boundary sought to be inserted by the petitioner decree holder is totally different except the southern direction to that of the boundary shown by the schedule of the plan with the decretal land. In the said suit, plaintiff has paid for eviction of the defendant from the suit land. Decree holder in the present petition though has stated that he put the boundary in his plan as per the sale deed executed in his favor for the suit land, but from the perusal of record it reveals that he has not filed the sale deed in this suit to ascertain the truthful of the submission. That apart, he has not been any effort to file the sale deed in support of his petition under the present facts and circumstance when question has arisen regarding identity of decretal land. Moreover, decree holder has also failed to satisfy the court that boundary has changed after the institution of suit to the death or transfer, situated thus allows the petition would amount to change the subject matter of the suit. Moreover, as laid down in the section 152 of the CPC and also from the judgment relied upon the OP, it reveals that executing court cannot allow correction of clerical arithmetical mistake in judgment, decree or order or errors arising therein from any accidental slip omission. In the case in hand, the omission to mention the correct schedule cannot be considered accidental slip or omission as it goes to the merit of the case, situated thus prayer for petitioner to allow the amend decree decree with regard to the four boundaries of the suit land is rejected. Besides that, from the report of the bailiff, Latmandal, as well as from the petition itself reveals that the decree has been passed on the wrong schedule. The decretal land cannot be identified in terms of the schedule appended to the plan, and the decree situated that it would be worthless to continue with the execution on a wrong schedule, and accordingly, as per the prayer of judgment debtor made in the petition, so proceeding is dropped. The execution proceeding is dropped, thereby, my lord, they nullified the decree passed by the in title suit, confirmed by the first appellate and the second appellate court. And my lord, that there is no third party came before the court disputing the identity. That is the only defendant, and defendant during the trial, my lord, or appeal, never disputed the identity. And my lord, whether the sale deed is produced or, my lord, that decreed the suit on behalf of, my lord, evidence on record and other, my lord, documents, that is Jamabandi, that has the finalized by the first appellate court or the second appellate court. That question cannot raise in the execution stage, my lord. Once the court satisfied, my lord, decreed the suit. And my lord, would that affect, my lord, in plethora of decision, my lord, the Supreme, right from the, my lord, Prohibitions Patil, I am, my lord, giving the judgment, my lord. That's all. Prohibitions Patil, no? Now, all the judgment I have made a short note, my lord. The first one is, my lord, Prohibitions Patil case, my lord. Para 16 of the judgment, my lord. Your lordship may. Because, my lord, once the suit is decreed, that para 16 says so, my lord, when suit as to immovable property has been decreed and property is not definitely identified, the defect in the court record caused by overlooking the provision contained in Order 7, Rule 3 and Order 20, Rule 3 of CPC is capable of being cured. After all, a successful plaintiff should not deprive from the fruit of decree restore can be held in section 152 or section 47 of the CPC depending on facts and circumstances of the case. Which of the two provisions would be more appropriate, just and convenient to invoke? Being inadvertent error not affecting the merit of the case, it may be corrected under section 152 of the CPC by court which passed by the decree by supplying the omission. Alternatively, the exact description of decretal property may be ascertained by executing court as a question relating to execution, discharge or satisfaction of decree within the meaning of section 47 CPC. A decree of competent court should not, as far as practicable, be allowed to be defeated on account of accidental slip or omission. In fact of circumstances of the present case, we think it would be more appropriate to invoke section 47 CPC. Second case is, my lord, Robindra Kaur versus Ashok Kumar, 2003. The same line, my lord. In para 19, it says, my lord, raising dispute regard to description of identity of the suit schedule property or a dispute in regard to boundary of the suit schedule property is only a bogey of delay of eviction by the abuse of the process of court. Court of law should be careful enough to see through such diabolical plan of the judgment debtor to deny the decree holder the fruit of the decree obtained by them.
Yes.
And our High Court also, my lord, in Manoranjan Datta versus Narayan Dhar in 2006 for GLT, in the same line it has been stated in para 15, main objection of the judgment debtor is that the suit property has not been properly identified, giving necessary description of boundaries in the plan at various paragraph, but defense has not taken any plea made that the suit line is unidentifiable, is not identifiable, because regarding the identity that in the trial stage or appellate stage that never come, no third party has come under section 47, my lord, because the only defendant has raised the objection. And my lord, thereafter the another case, my lord, Dwaraka Prasad versus Nilkamal Besbarua, my lord. That is, my lord, 2015 to JLT, our High Court, my lord. In para 15 and 17, it is clarified, my lord. When a suit as to immovable property has been decreed and property is not definitely identified, the defect in the court record caused by overlooking the provision contained Order 7 Rule 3 and Order 20 Rule 3 of the CPC is capable of being cured on the basis of Pratibha Singh Patel that relied, my lord. That judgment has been, I have given, my lord. And my lord, lastly, my lord, in the Supreme Court says, my lord, because of, my lord, several cases throughout the India, my lord, after long battle, my lord, 10 to 20, 20 to 30 years, my lord, at the execution stage, my lord, that all are, my lord, hold as installed. That's why, my lord, in the recent judgment in 2025, my lord, Periamal versus Rajmoni and others, my lord, it specifically directed, my lord, that all the execution should be completed within 6 months, my lord. Para 75 in the trigger I am reading, my lord. I am not passing, my lord, that I am passing to you, my lord. In view of the aforesaid, we direct all High Court across the country to call for the necessary information from their respective district judiciary as regard to pendency of execution petition. Once the data is collected by each of the High Court shall thereafter proceed to issue administrative order or circular directing their respective district judiciary to ensure that the execution petition pending in various courts shall be decided and dispute of within a period of 6 months without fail. Otherwise, the concerned presiding officer would be.
Yes, it has been disposed.
That means I'm giving bill.
It has been not necessary.
No, not necessary to that because
That judgment has
we
been
are-
complied with.
Yes, my lord.
It does not say that execution is to be executed. It says execution is to be completed. The
My lord.
proceeding is to be completed.
Yes,
Proceeding can
proceeding
be
is-
completed
because
by
proceeding
dropping
is-
also.
Proceeding is stayed because that's why, my lord. Because of that, the intention of this intention that in the execution stage, that my lord, the decree holder shall not be deprived from the fruit of the judgment and decree. That is the main intention. And Pratibha Singh Patil case, my lord, it is specifically stated.
Yes.
My
Now,
lord, and what the
according
what,
to
my
your
lord?
new boundary,
Yes, my lord.
these names have come in.
Yes,
Chandra
my lord.
Talukdar, Pipeline, Gangadas, Prasanta Saikia,
Yes, my lord.
North, South, East, West.
That except the, my lord, that pipeline that others has changed because of the it is the salary is of 75, my lords. That's why, my lord, it has happened. And the court that the learned court below they relied that the judgment, which is, my lord, that Dwaraka Das versus Madhya Pradesh, that here, my lord, what happened that in that case, my lord, that the in a money suit, my lord, money suit earlier, my lord, that I am giving that judgment in money suit earlier, my lord, interest was not calculated. That's why, my lord, Dwaraka Das and Madhya Pradesh, my lord, interest was not calculated, that's why 152, that was rejected. And that's what relied by the learned court below, that is I am giving. That is rejected because earlier case, my lord, that interest was not specifically pleaded. That's why, my lord, subsequently, my lord, 152 petition is given for calculating the interest. That case is not, my lord, resemble is the fitted case in this case, my lord. Because they have to.
Yes.
So, my lord, that it is settled law in the Pratibha Singh Patel, my lord, a decree holder cannot be deprived from the fruit of the judgment, and the court can be that in regard to immovable
All that
property.
is all right, but once you submit this application saying that these are the new boundaries, how
Yes,
is
my
the
lord.
court supposed to proceed? Is it supposed to take it at its face value? Are you required to prove that these are the present boundaries? What step is required to be taken by the court in that regard?
The court may in execution stage, my lord, even if court, my lord, give a chance to, my lord, in spite of dismissing, my lord, they give a chance to, my lord, prove, even if under section 47.
Yes, respondent.
Because ultimately it's amount to nullify the decree.
Yes, what do you say?
My lord, please turn to the page number 24, my lord, of his petition, my lord.
Yes.
Here, my lord, at para 5, he stated that the decree is therefore required to be amended by inserting the four boundaries of the suit land for effective execution of the same as set forth in the schedule below. So, the petitioner here want to insert the boundary in the decree, not amendment of the plain. By amending of the plain, decree is to be inserted, my lord, because decree is prepared from the plain, my lord. Here, plain is same. Plain is not required. He is not prayed to amend the plain here. So everything, all the judgment, those stated, but this judgment has not stated that decree is to be amended, my lord. The decree, how decree is to be amended? Decree is to be amended from the plain, my lord. This decree, the boundary of this four boundaries of the land is to be inserted in the decree from the plain, my lord. He has not prayed for amendment of the plain. Another thing is that, my lord, what wrong has been done in the passing the order, impugn order, the learned friend has not stated. Because it is clearly stated in the order that had there been here in the last 34 page, my lord, it is clearly stated that apart from he has even not made any effort to file the sale deed in support of his petition under present facts and circumstances. So how the veracity comes, my lord? If he has not filed the sale deed, then how the court will presume that this is the true boundary? There is no any nexus, my lord. No, nothing is brought before this honorable court or in the trial court, my lord, that the boundary is said. And that has already been discussed by the learned trial court, my lord. So my humble submission that there is the scope of section 152 only arise for decree, and it is the learned trial court has clearly observed that nothing has been wrong done by the trial court in declaring the suit. This is my humble submission.
All right, CAB.
Yeah.
Hearing আছে নেকি আৰু? আছে।
I'm being 46.
Please, your lordship.
What is the matter about? This is.
My lord, appellate before your lordship had filed a suit for injunction only, permanent injunction only, before the learned trial court of civil justice senior division number 3 at Gauhati, my lord. Along with the plate, my lord, one injunction application was also filed for temporary injunction. But learned trial court, after one motion, my lord, after hearing the counsel for the petition, petitioner, had issued show cause notice only. According to the region, that there is no urgency. Although, my lord, in the entire suit, the illegal acts of respondent scheduled to be commenced from 11th of February was challenged in the suit. An order was passed on 9th of February. Finding prima facie finding is that there is no urgency in the suit. And virtually, my lord, by with the suit is only for permanent injunction, virtually by rejecting the prayer for administrative injunction, suit has been dismissed. Virtually, my lord, granting liberty to the respondent to go ahead with their activities. This is not permissible, my lord, because when the suit itself is for permanent injunction, to preserve the subject matter in dispute, the both the parties ought to have been directed to maintain status quo till the issues are decided by the trial court after leading evidences.
Right. Right, it's time, I think, already. Oh. Give me the factual background first.
Naturally. Lordship, there is a big real estate project in the name and style of Protect Group, my lord. And this group consists of various partnership firms and companies, my lord. And parties to this litigation are the part and parcel of their project, my lord. Protect Group, my lord. Some disputes had arisen, my lord, in respect of management and affairs of the partnership firm, my lord. Litigations have been initiated from both the sides, my lord. Those are apparent from the perusal of the impugned order. Lastly, my lord, your lordship may kindly see one suit has been filed, TS 26625, by the other concerns from the present petition appellant, along with others, my lord, which is still pending in the Court of London Civil Justice Division number 3 at Gauhati, TS 266 2025.
In this suit, my lord, the petition appellant before your lordship had prayed for comprehensive relief in respect of the entire assets and liabilities of appellant number 1. And that matter has been posted, my lord, for hearing. After filing, my lord, the suit, my lord, defendants, the present respondent number 1 and 2 had filed application under section 8 of the Arbitration and Conciliation Act 1996, stating that suit is not patentable in view of containing arbitration clause in the partnership deed. So that issue is pending on my lord for the final disposal, and hearing could not be completed before the trial court. In the meantime, your lordship may take further judicial note. The other proceeding, my lord, initiated by present respondent number 1 by way of misarbitration case number 9 of 2024. Your lordship may kind of see annexure 10, page 91. Annexure 10, my lord, page 91. This was initiated by present respondent number 2, acting as partner of Pride Realty, along with others, my lord, in respect of operation of bank account. This matter was heard at length by the learned trial court, and the matter was for orders, my lord, on 17/2/2025, my lord. The orders, yes. Your lordship cannot see page 222 and 223, my lord. 223 is relevant, my lord. This matter hearing was concluded on, my lord, 29 1
Page?
page, my lord, 223, my lord. Hearing was concluded, matter was posted for orders on 17/2/26, my lord. After this, my lord, with an anticipation of any adverse order, my lord, respondent number 1 had floated social media circulation. Your lordship cannot see annexure 15, page 219. Scheduling proposed handover of the project of present appellant number 1 at Nagar, my lord.
Page?
Page, my lord, 219. 219, annexure 15, my lord. And my lord, this is 219 is vernacular, and my lord, translation. Translated portion is at my lord, page number 220.
Then?
So, my lord, this schedule was, your lordship cannot see, this was scheduled from 4th February. 11th February, yes, my lord. This was scheduled for 11th February for, my lord, an event in respect of the present appellant number 1 at Nagar, my lord. Earlier, my lord, this was floated that there was puja and other rituals, my lord, in respect of this project at Nagar, my lord. Then, my lord, the suit was filed only for injunction that this event should not be allowed to be held by present respondents, my lord, by discarding the present appellants, my lord, because they are admittedly partners in the appellant number 1, my lord. This position of fact is not in dispute, my lord. They are major stakeholder in the firm. Behind their back, my lord, the respondent number 2 has circulated for this event, my lord, starting from 11th of February, showing that there will be puja ceremonies. Then, my lord, the suit was filed, and learned trial court, the lordship cannot see, was pleased to take up this matter for order on 9/2/26. Annexure 20, my lord, any MPO order, starting from page 285. Event was scheduled on 11/2. From 11/2, my lord, this matter was taken up for order on 9/2 by the trial court, my lord. Page 285, annexure 20, my lord.
This whole contention is with regard to the organization of that event.
Organization of event, my lord, behind the back of the appealants, my lord. Full condition, my lord, nothing else. Your lordship cannot to take a judicial note, my lord. At page 26, my lord, page, my lord, 249.
But now today is what?
No, my lord.
Today is 18th.
Lordship, what has compelled the appellant to approach this honorable court, my lord? They have, in view of a refusal of injunction by the trial court, my lord, they have completed the event of scheduled from 11th of February, my lord. Now, my lord, they have rescheduled their event for next page. By virtue of your lordship, may cannot see in Extra 21, page 299. After the refusal of injunction by the trial court. Now, this is their scheduled event. Mhm. Edition 15, my lord, page 219 having two part of scheduled events. One was to be started, commenced from 11th of February. Next one from 18th February. Earlier, my lord, by virtue of an issue
299 is some Facebook post.
My lord,
Does
my
not
lord.
say about any event.
No, my lord, your lordship, I can see this page number 299 is required to be seen in comparison with page number 219. Your lordship, I cannot see page number 219. Here in next page was
From 18 to 24th.
initial 15, my lord, to page 219.
Yes.
My lord, this
But Bhagavad Katha, that is
my lord, my lord.
24th.
Earlier this was circulated for spiritual rituals only. Now, my lord, your lordship, I cannot see what they have circulated. Handover ceremony in page 299, my lord. Scheduled to be commenced from today. Behind the back of the appellant, my lord. Although, my lord, this is an immediate position of fact, appellants are the partners of the appellant number one, having major stake in the partnership firm, my lord. By giving total go back to them, my lord, they have been concluding, and you also further take judicial note. Who are these persons, my lord, showing in the picture? Respondent number 2 and 3 only, and their relative.
What judicial note?
My lord, because my lord, appellants have been discarded there from, my lord. Admittedly, they are partner, my lord.
What judicial note do you want us to take of the person in the photo?
No, my lord. This circulation, my lord. This circulation shows their malified intention to discard the other partners of the firm. This was my submission, your lordship.
Part of your record, what
My
judicial
lord.
note is required to be taken?
My
You're
lord.
taking note of the record there.
My lord. My lord, this shows that, my lord, they are going to discard the other partners of the party, appellant number one, my lord, to satisfy their illegal whims and aspirations. Now, your lordship, you can see the impugn order. Findings as just recorded by the land trial court.
I'm trying to understand one thing. You were on that ceremony.
No, my lord.
That was scheduled on 11th.
My lord.
Some Pran Pratishtha ceremony was
lord.
supposed
My
to be
lord.
there.
We have been,
Then now about handing over ceremony.
no, my lord, we have been debarred.
Debarred from participating in the ceremony.
We have not been allowed to be part of the ceremony, my lord. That is our grievances, my lord.
Nothing with relationship, nothing with regard to execution of the project, ownership, no such dispute like that. Only this participation in the ceremony. That is
My lord, in respect of other issues, my lord, other litigations are pending.
all right. We are here
We
concerned with the present.
cannot agitate the issues repeatedly, my lord. So here in this case, my lord, full issue is in respect of commencement of the event. Because this event has been intended, my lord, by discarding the other partner, right of the other partners. And this has been, my lord, intended to enhance the goodwill and reputation of the firm by respondent number 1 alone. Respondent number 2 alone. The lordship can see in the impugn order, the reasonings have been recorded by the land trial court. Para 14, lordship, I cannot see page 292.
Page
Para 14, my lord, page 292 of the impugned order. My lord.
is
Para 14, my lord, at the top, my lord, petitioner is stated in para 13 of the plaint that the mediation settlement agreement, in short, dated 23/9/24, has been executed between the parties before the Honorable Gauhati High Court in Miss Arbitration Case number 205/24. The petitioner has further stated clause number 7 of MSA specifically provides project at Tornagar will be completed jointly. This is an important point. If MSA says Tornagar project must be completed together, then both the petitioner and OPs have equal rights and duties. The term jointly means decisions should be made together and neither side can act alone. Paragraph 15. The petitioner requests to prevent the office from the holding any event appears to be conflict of the MSA, which calls a joint completion and management. The petitioner cannot use MSA for some argument and ignore it for others. My lord, we have not adopted some part and ignored other part, my lord. My say, my lord, this should be jointly. We should not be discarded therefore. But my lord, proposed event shows we have been discarded therefore, which compel us to approve the trial court. The next para 60, my lord. An important fact from the petitioner's statement is that Project Karunnagar project is mostly finished and possession has been given to eligible flat buyers who have started their interior works, para 36. This shows that construction is nearly done, flat ready, basic facilities are available and project is suitable for living. Even these facts, the petitioner concerned that holding an event would cause serious harm seems overstated. If the project is almost finished and buyers have taken possession, holding such event is normal part of the real estate business, my lord. This is incorrect, my lord. This is not correct finding by the trial court. Priority, my lord. Court must give priority to the interest of the flat buyers who have invested their savings in the Project Karunnagar project. The buyers are not involved in the dispute and have trusted the petitioner firm, hoping to secure home for their families. The petitioner has said the possession was given in 2025. This means buyers have paid large sum of money. They have taken home loans and they have spent more on interiors, and they rightly expect the project to be completed with all promised facilities. Granting ad interim injunction would harm the buyers, creating uncertainty and delaying any remaining work. My lord, nowhere in the plaint. For this purpose, your lordship, I cannot see what has been prayed for before the trial court, my lord, in the suit. Only injunction, my lord, regarding event. No other activities have been restrained, my lord, prayed for any restrainment. Prayer portion of the plate, your lordship, I cannot see page 249. The suit is not for infringement of any right of the flat purchasers, my lord, in any manner. Page 249, my lord. Prayer portion, lordship got it.
page
Page 249, my lord. This is the prayer portion of plaint.
is
Lordship, prayer number 1, permanent injunction restraining defendants, their employees, workmen, agents, associates, and subjects from conducting any event in the project of Protect Tornagar under plaintiff firm, and further restraining, eliminating, and encompassing the same in any manner as described in the schedule below, unilaterally, single-handedly, and behind the back of all the partners of the plaintiff firm. My lord, by way of this prayer, my lord, no harm is going to be caused to the flat purchasers, my lord, in any manner. Because my lord, plate says the flat purchasers have already been handed over the position. They have completed their interiors. Some of them have also started residing thereon. Right? Intention of the plaintiff by filing this suit not to cause any harm to the flat purchasers. But Learned Trial Court has recorded that this will harm the flat purchasers. Next, my lord, I am coming to page 293, my lord, paragraph 19. Page 293, my lord. Paragraph 19. Granting identity injunction would harm the flat buyer by creating uncertainty, delaying the remaining work. The buyer are not part of the internal dispute and should not be made to suffer because of them. The interest of the buyer must be considered and any temporary order should respect their expectation. In addition, buyers' investments, real estate project require substantial fund for construction, infrastructure and development. The petitioner firm and its partners, including OPs, would have spent crores on land, building infrastructure and amenities for Protect Tornagar project. Holding an event mark of completion of a normal business practice is serves several purposes, including formal handover and celebration. Lordship, I cannot take Note, it serves civil purposes, including handing of formal handover and celebration, marketing, brand promotion. This is the allegation, my lord. My lord, respondent number 2 has been trying to encourage the brand promotion marketing by taking the goodwill and reputation of the firm by him alone, behind the back of the other partners, my lord. Although, my lord, share of the other partners is not in dispute. Stopping such event without hearing other side would hurt the firm's business and lower buyer's confidence, sending a negative message to the project future. Officer partners have invested heavily and have a financial interest in the project. Granting an injunction in favor of one partner without hearing others would not be fair or just. For the first test, granting of temporary injunction, the court must see if the petitioner has a basic case. After reviewing the documents, the court finds that petitioner does not have a strong prima facie case for an administrative injunction. The case depends on disputed facts and how the partnership deeds and FSI are interpreted, which needs a full hearing. Petitioner is also asking an injunction against its own participant, which needs proper review in the main suit. My lord, if there is something left out, my lord, at the time of consideration of my prayer for temporary injunction to be decided in suit, my lord, this shows that I am having prima facie case. I could able to place before the trial court a prima facie case requiring trial. Till completion of trial, subject matter in dispute is required to be protected. Now, my lord, I am coming to paragraph 22, page 295. For the second test, it appears that the balance of convenience does not support the petitioner. It favors the office, especially flat buyers. Granting of injunction would cause problems for buyers, delaying project and hurt the firm's business. My lord, this is the finding in respect of balance of conveniences, my lord, in a dotted line. Now, lordship, I cannot see paragraph 296, my lord, page 296, paragraph 17. Paragraph 27, my lord, page 296. Given the nature of this vote and the many parties involved, including pro forma office, who are also partners, it is not appropriate to issue an order without hearing everyone. This court does not see enough urgency to skip the notice. Legal natural justice means everyone affected by the court order should have a chance to present their sides. The office, as equal partners, have right to be heard before any order to that effect their rights. The petitioner has not shown sufficient urgency or an imminent risk of to warrant skipping of notice. The event is set for 11/2/26, so there is enough time to send notice and to hear the same. My lord, this order was passed on 9th February. Event was scheduled on 11th February. And trial court has recorded the reason that there is no urgency skipping the notice, my lord. My lord, in this respect, I have already mentioned, my lord, in my memo of appeal, the division bench judgment of our High Court, my lord. Your lordship cannot see page 33 of memo of appeal. It is reflected in ground number 10 of memo of appeal. Page 33. Your lordship got it?
This injunction application was with respect to the event
Only event, my lord.
scheduled to be held on 11th.
My lord.
But that has passed.
Now, my lord, next schedule is due from today, which is to be started from today.
No, but in that injunction application, you were on that
My lord.
event of 11,
My lord. One part has been
not on the other event.
in totality, my lord.
Which did you challenge?
My lord, this your lordship may kind of see annexure 15 I am challenging, my lord, wherein there are two parts. Due to refusal of injunction by the trial court, they have completed the first part. Now next schedule is commencing from today, evening onwards, which is to be continued till 24th of February 26. Annexure 15, my lord. Now I am concerned with the next phase of this event, my lord.
Yes.
My lord, page 33 of memo of appeal, my lord, ground number 10, my lord. I've shown the relief shortfall in the entire plain, my lord, which is only for degree for permanent injunction, my lord. May I read, lordship? Page 33.
This is what? This is the
Memo of appeal,
Memo of appeal.
ground number 10, my lord.
Yes.
May I please? For the para 12 of AIR 1982 Gauhati 69, my lord, this is the divisional judgment of this honorable court, my lord. Specifically speaks that the circumstances under which temporary injunction may be granted have now been more or less crystallized, where in any suit it is proved by affidavit or otherwise that any party in dispute is in danger of being worsted, damaged, or alienated by any party to the suit, or to restrain the defendant from committing injury of any kind relating to the same property or right, the court may grant a temporary injunction at its discretion on such terms as to the duration of the injunction and subject to the condition as the court thinks fit. Where the defendant has committed or is threatening what the plaintiff alleges to be a trespasser or a wrong, the plaintiff may ask the court to direct the subject matter of dispute to be maintained in status quo till the issues between the parties have determined. My lord, here in this case, landed trial court says there are some tribal issues to be decided in trial of the suit. Till then, my lord, this was the duty of the landed trial court with all respect and regard to preserve the subject matter in dispute by way of status quo. Although, my lord, this case law was placed before the trial court, my lord, the landed trial court has not considered the same. No finding has been recorded in the appealing order. Hence, my lord, with all respect and regard, interference of the Supreme Court is required. Which? Lordship, I cannot turn to page 61, my lord. The intention of the respondent becomes transparent, clear enough.
Sixty-one,
my lord, Annexure 5. My lord, this is the official website of Protect Group, who is appealed before your lordship as well as respondent before lordship, my lord. My lord, respondent number 2 has been carrying on identical business in the name and style, brand name and style of Ambika Group. Wherein, my lord, in the official website of both Ambika Group and Protect Group, respondent number 2 himself has been showing that he is the founder of the Ambika Group website and Protect Group website, my lord. Although he is having only 20% share in the partnership firm, in the project group. This way, my lord, he has been doing business conflict to the interest of the applicant number 1. Everywhere, my lord, he has been projecting that he is whole and soul of the entire Protect Group, which is not correct, my lord.
yes.
My lord, along with this appeal, one injunction application has also been filed separately, my lord. Being I number 458, my lord, for consideration of period for temporary injunction, my lord.
Yes.
Wait, please, Mr. Lord. Lord, I've entered appearance for 1, 2, and 3, my lord. Now, my lord, the order in question is a reasoned order, and the suit, with utmost respect, is utterly frivolous, my lord. Now, what has happened is, my lord, this, of course, I'm yet to file my response either in the suit or in the appeal, my lord. There's a long checkered history, my lord, half of which is not even disclosed in the suit or the appeal memo, my lord. What has happened is, my lord, Protect Group is a conglomerate. It has various firms and companies, LLPs, etc. Now, this comprises essentially of 2 families, the Singhal family and the Jalan family. everything is going smoothly, my lord. It has a lot of goodwill in the market, etc. Now, the petitioner or the appellant before your lordship had developed some grievances against his own family members, including his own brother, then the members of the Jalan family. And he goes on a rampage, as in he first approaches the banks to say that the operations of the bank account should be frozen because my brother and the members of the Jalan family have cheated me. He comes up with vile allegation and he gets the account frozen. Therefore, we are compelled to approach the court under Section 9 because essentially this is an arbitrable dispute. I can show the arbitration clause even in the partnership agreement, my lord, which is at page 50. So we are compelled because the bank freezes the operations at his instance, and therefore we approach the court under Section 9 of the Arbitration and Conciliation Act. And at page 119, the Learned Commercial Code grants an order of injunction that you will defreeze the account and restrains that partner, disgruntled partner, not to take any steps for freezing of the accounts. That proceeding eventually was disposed of yesterday, and the order has been confirmed in our favor. Thereafter, my lord, once we have that Section 9 order, my lord, he files 3 suits back to back against all of the other entities of the Protect Group. First suit he files to get an injunction in respect of a ongoing project, my lord. Second, he files another suit to again freeze the accounts of the second Protect Housing, the very firm before your honor. And in fact, if your honor may kindly have the memo, that particular suit, which is prior in point of time, is available in the record. But if your lordship has page 198. So this is not the first instance that they have come challenging an ad interim order. On an earlier occasion also, in the prior suit filed in the name of Protect Housing, an order of injunction was declined, which is why they approached this honorable court in an FAO. Curiously, my lord, this particular order, though annexed, if your lordship has page 210, so this was the first, the earlier suit, again in the name of Protect Housing. On that occasion, they had attempted to stop the operations of the bank account on the ground of some KYC, etc. So page 210, that order is annexed, that is dated 30/10/2025. It says, let the case be listed for delivery of orders on 7/11/2025. Curiously, my lord, that order does not find place here. I'll just pass on. It's an order passed by this honorable court. If your lordship has para 21 onwards. Para 21 has it. The dispute between the parties involves several partnership firms, private limited companies, and limited liability partnerships comprising the Protect Group. It also appears that the relevant deeds, articles of associations contain arbitration clauses therein for resolution of dispute. It also appears from the materials on record that misarbitration case number 205 of 2024 is pending before the Court of Learned Civil Judge Senior Division, wherein by order dated 19/12/2024, the court has injuncted the appellant number 2 from taking any steps for freezing the accounts of the sister companies, subsidiaries, or parent companies of the Protect Group. The said order is still in force. It appears that while declining to grant ex parte injunction to the present appellants in Miss Case so-and-so, the trial court took into consideration the above aspects. Since it appears that the Protect Group is mainly into the business of real estate, construction of flats, the trial court also took into consideration the welfare and the stakes of the customers who had booked flats with various entities of Protect Group. The trial court has categorically stated in the impugned order that since the interest of the customers and their hard-earned money is at the foremost, every detail needs to be taken care taken care of to find out in whose favor the balance of convenience tilt. Therefore, it issued notice to the opposite party and fixed a very short date in the said Miss J case number so and so. Under Order 39, Rule 3 of the Code of Civil Procedure 1908, the court may grant a temporary injunction even without giving notice to the application to the opposite party, only if it is satisfied that the object of granting the injunction would be defeated by delay. Thus, only in cases where time is of essence and any delay caused in issuance of notice may defeat the purpose of granting temporary injunction, an ex parte ad interim injunction may be justified. However, in the instant case, the dispute is going on between the parties since 2024, and it was only on 10/12/2024 the appellant number 2 wrote to the respondent 1 and 2 to conduct re-verification of KYC, to which the bank authority replied on so and so itself, whereas the appellant instituted the title suit 266 of 2025 only on 2/5/2025. So basically, it declined to interfere with the rejection of the ad interim order, my lord. So this is what is happening, my lord. There is a Section 9 order in my favor. There are 3 back-to-back suits filed, despite there being an arbitration clause. There is an application under Section 11 for appointment of the arbitrator pending before this court. There is also civil revision, and on top of that, my lord, this is virtually an abuse of the process. They filed a fresh suit now to sort of injunct and stall an event. Now, what is that event? That event is basically a ceremony, and allotments are being handed over to almost 270 families. It's a huge project. Now, at this juncture, if they seek an injunction, the idea is quite apparent. They want to exert pressure on the other partners and to create panic among the customers that we have an order of injunction here. They've attempted that 4 times, they failed, and now this is a fresh salvo to sort of get an order of injunction, create panic in the market. So what the partner is essentially trying to do is he's jeopardizing his own business, his own firm's goodwill, my lord. Now, what is the urgency, my lord? He himself says that the project is complete. In fact, I have the occupancy certificates. The half of the flats have already been allotted. Now, if there is a ceremony, in the midst of a ceremony, they want to go and sort of place an injunction order just to create panic and sort of exert pressure on the arm twist the other partners to concede to his demand. That is essentially the claim of the petitioner, my lord. Now, on the face of it, this is of course on facts, my lord, where I have not had the opportunity to file a defense, my lord, so far. Now, even on maintainability, your lordship will kindly see page 50 of the memo of appeal. I'm sorry, my lord. I'm sorry, 58, 58. That clause 20, that all disputes concerning the partnership firm, if cannot be settled mutually, shall be referred to the arbitrators to be appointed under the relevant arbitration law. Now, we are aware, my lord, Section 5 of the Arbitration Act is very clear that regular courts will refrain from sort of interfering or acting in any matter which is arbitrable in nature. So, suit prima facie by their own showing is not even maintainable, my lord.
What is this? Does this agreement?
This is the partnership deal.
Agreement.
The partnership deal.
Between Protect Bilcon Private Limited and Protect Realtors Private.
My lord, all the partners, my lord. In fact, this was your lordship has page 51. Your lordship will find the name of the partners. Now, subsequently, the appellant before your lordship was inducted subsequently by a deed of admission, which your lordship finds at page 44. Originally, he was not a partner. He was inducted later on.
Page 44.
44, that's correct. Now, going by the partnership that they've annexed, the dispute is arbitrable. In fact, there is a Section 9 order, Malad, there's an application pending for appointment of arbitrator, and in the midst of all this, the appellant files suits after suits, Malad. In fact, there are 4 suits now. The matter is, and in fact, in one of the suit, a Section 8 application is already pending because ultimately this is arbitrable in nature. Now, if your lordship has the application for injunction at page 275, if I may just show a few of the paragraphs. Page 275, if your lordship has, this is the premise on which they want an injunction. Para 35, my lord, that in a similar manner, after final hearing of misarbitration case 205 of 2024, that's a Section 9 proceeding, filed by the principal defendants herein was conducted on 29/1/2026 and was reserved for final order on 17/2/2026, that is yesterday, my lord. Again, in the malafide manner and the most illegally way, Shri so-and-so and other defendant, fearing that the order may result against them, have planned to illegally conduct an elaborate event at Project Tarun Nagar project under plaintiff firm starting from 11/2/2026 for a 2-long-week program just to illegitimately gain the sole credit, goodwill, and attract the attention of valued customers of Greater Gauhati in the brand of Protect Group only from his mega project without the work even being fully complete as per brochure and quality standards, especially in the common areas, and that too when Mr. So-and-so and family are parallelly engaged in another real estate business under Ambika Group. Now, if I may pause here for a moment, they say that when orders were reserved in the Section 9 application, we were apprehensive that they'll go eventually against us, which is why we planned this event. That apprehension is wrong because the order has finally gone in our favor. I have the order with me. Secondly, my lord, they say that the works are not complete, my lord. We have documents to show everything is done. In fact, in the subsequent paragraph, your lordship will find half of the handover has already been done. Now, paragraph 37, he calls that the event is illegally planned. And he tries to espouse the cause of the flat buyers instead. And he says that again, if this illegally planned event by so-and-so takes place with work still pending, the flat purchasers, even after paying huge sums of money to purchase their dream flats, will be at a huge loss and suffering due to incomplete work, especially in the common areas. And if the project is not completed as per the quality standards shown in the brochure, the flat buyers may file multiple legal proceedings and lodge complaints before the RERA authority. So he tries to show his bona fide and say that I'm worried about the flat buyers, what will happen to them? And look at now, if your lordship has the prayer at page 280, he sort of tries to espouse the cause of the flat buyers and on one breath, and on the other hand, he's seeking an injunction to even hand over the flats. Page 280, Manoj.
Yes.
An ad interim injunction restraining the defendants, their employees, workmen, agents, and servants from conducting any event in the project of Project Tarun Nagar under the plaintiff, and from, your lordship will mark those second part of it, and from further transferring, alienating, and encumbering the same in any manner as described in the schedule below, unilaterally, single-handedly, and behind the back of all the partners of the plaintiff firm. So on one hand, he shows so much of concern for the flat buyers, my lord. On the other hand, he's trying to stall the very allotment in the name of the flat buyers, my lord. Now, all said and done, my lord, ultimately, we are all aware of the scope of an appeal against an order of injunction, which is discretionary in nature, and that to an ad interim order. Now, the trial court has not really disposed of the miscase. It has merely said that I will hear the other side before I eventually pass an order of injunction. It is fixed now on 10th of March. Now, your lordship has already seen the order of our High Court in the earlier round, where the High Court took note of the fact that this is merely against an ad interim order. Why don't you contest the proceeding? And ultimately, my lord, if your lordship sees the earlier suit also, that is at page 136, my lord. It is also bad for the vice of section 10. In 136, this is the earlier suit, again by Protect Housing. So concerning the affairs of a single entity, if you file two suits, there are almost 11 entities. He'll keep on filing suits after suits so that he gets some order of injunction whereby he can sort of exert pressure on the partners. And it is not as if that the entire majority shareholders are with the plaintiff appellant. In fact, his own brother, I'm holding the Wakalatnama, my lord, his grandmother, then the members of the Jalan family. So there is just one disgruntled member who has some grievances against the partners, and for that he wants to stall the entire project. And these are RERA projects, my lord. If I miss out on the timeline, there are huge penalties that may entail. So, first of all, and the order your lordship has already seen is a well-reasoned order. It says flat buyers take are at risk, which a reasoning which this honorable court had also endorsed in the earlier round, the order which I just placed, that the trial court must be conscious of the rights of the flat buyers. Secondly, my lord, it also takes in note of the fact that it is overstated. What is your apprehension? I'll go conduct a puja with all the flat buyers. Where is the question of granting an injunction to carry out a ceremony, my lord? So, which is why the court said that this is overstated. No, heavens will not fall if a ceremony is conducted. And so far as the other part of the prayer is concerned, that's outrageous. You are your own flat buyers. You are trying to stall the allotments in their favor, my lord. So, my lord, will give me a chance because there's been so many litigations after litigations. I'll file my objection, my lord, and if your lordship desires, your lordship can relegate us to the trial court, my lord. We'll file our objection. First thing first, the court has to take a decision whether the suit itself at all is maintainable in view of the arbitration clause and also in view of the earlier suit, which is already also pending. So the subsequent suit may not is apparently by section 10 CPC, my lord. So, lord, I'll bring on record all the orders, my lord, that have been passed so far. The section 9 order, I already have it with me. The section 9 court has also taken note of that this is wanton misconduct by a partner. If you try to harm your own firm's goodwill, so you should be in fact restrained from taking any action for, freezing accounts, etc. So that order still holds the field. In fact, that has been confirmed yesterday, my lord. The order of this honorable court in the FAO, which I just passed on, also remains. That also says flat buyers' interests are paramount. You can, the court should not, is right in not granting ad interim injunctions. Now, this third attempt, my lord, in fact, fourth attempt, my lord, there are two more which I'll bring on record. It's an abuse of the process, my lord. It's an arbitrable dispute. They should concede for an arbitration all disputes, since it's a group of companies. Going by the group of companies doctrine, all of the disputes can be resolved comprehensively by arbitration, but they file suit after suit. And the idea is very simple, my lord. Just to get an order of ad interim injunction. That's the only objective. Because otherwise my friend has already read out the plain. It's a suit simpliciter for injunction. If you have a problem as a partner, you file a suit for dissolution or rendition of accounts. Why will you style it as a suit simpliciter for injunction and then urge the court that since that is my only prayer, you have to protect me on day one? Regardless of what has been transpired so far, or the interest of the flat buyer. So, your lordship will kindly not entertain their prayer for ad interim. That such prayers have been made several times before, that have been discarded. I'll place all the orders on record, my lord, and maintain that order of the learned trial court, because that has not essentially decided the injunction matter. It has only deferred decision until all the partners appear, my lord. In fact, my lord, I must also point out that there is the judgments are not in accord, of course. There are different judgments of our own High Court. There's one line of authorities which have said that such orders where there is only notice simpliciter are not even appellable under 43(1)(r). So that is another question which perhaps which has said that if you grant an ad interim injunction, you can maintain an appeal under 43(1)(r). But if the court declines an ad interim order of injunction and merely issues notice, that's a order under Rule 3 and hence not appealable under 43(1)(r). Of course, I must concede that there are other judgments which have held otherwise. But that is another aspect perhaps which your lordship will like to take note of. On 15, 1 GLR 6. Page 630, para 19 onwards, if your lordship sees. At the outset, para 19, my lord. 630, 637, para 19. As your lordship found it. Para 19 begins at is at 637. I may read, no? Of course, that this point is of course debatable, my lord, because there are perhaps there have been occasions when such appeals have been entered.
Per se, if you say that it is not appealable, then when supposing a prima facie case is made out and time is of the essence, then what remedy does the applicant have?
That's debatable, like I said, my lord, but this is the judgment, last judgment, which took note of Akmal Ali of 1982 and eventually held that ultimately, if it's notice implicitor, an appeal may not lie. Lord, regardless of that, this was just one aspect I wanted to point out, my lord. Regardless of that, my lord, when it comes to ex parte ad interim, when it comes to injunctions, it's discretionary. The several judgments, including Vander and the recent ones, have said that unless it's out and out perverse or it's totally dehors the principle, the appellate court doesn't usually interfere, my lord. Secondly, given the nature of this particular injunction order, it's only the ad interim order. I mean, ad interim was declined. So in my view, with utmost respect, the scope should be even narrower because the trial court is yet to take a decision, my lord. Thirdly, on facts, it's very clear that there have been multiple litigations, multiple prayers made for injunction. And after all of those have been declined, they have come, my lord. Fourthly, my lord, the interest of the other partners and the flat buyers are at stake. That is something which the court took note of in the earlier round also, my lord. And lastly, my lord, ultimately, why should the flat buyers suffer, my lord? They have booked, there is a ceremony, everybody's participating in it, and then suddenly
Problem is you are not letting him participate.
no, but that has never been the case. My lord, in fact, I mean, I shouldn't say this, my lord, but ultimately the conduct itself will show that participation by him may be detrimental, my lord. And in fact, the Section 9 court has also held that his conduct has been not in the welfare of the firm, my lord. But having said that, we've not issued any sort of prohibition for him to participate, but the going by the nature that this is the order that they want, that I should not conduct any event, I should not allot, alienate, transfer, whatever. So we have timelines to meet, my lord. It is RERA, it is under the RERA, my lord. So therefore, the timeline, adherence to timelines is very important, my lord. Secondly, my lord, ultimately the flat buyer should not suffer. The project is almost finished by his own statement. Flats have already been handed over, my lord. And there are various other tribal issues. First of all, whether it's even maintainable given the arbitration clause, my lord. Of course, there has been allegation that the matter is already settled by virtue of a MSA, which your lordship finds at page 64. So they say now that there is a settlement, the arbitration clause dies, but that plea has also been discarded by the commercial court while dealing with that Section 9 application. Ultimately, this the entire goodwill of the firm, his own firm, is at stake.
Where is the order of the commercial court?
Commercial court final order, they have not annexed, but the Section 9 order, your lordship finds at page 119. So this ultimately will again lead to multiplicity, my lord, where it can be resolved at one forum, my lord.
Where is that order that you say has been passed April?
Sorry, my lord. Yesterday's order is here. Lord, in fact, at his instance, the operations of one of the firm's bank account was frozen twice, my lord. It created panic, my lord. All of, the operations were halted, my lord. And eventually, at the last page of that order, now your lordship finds the interim order. Yes, the interim order under Section 9, the final order. Given his conduct, the court was, I mean, we were compelled to approach the court and the court was satisfied that he should be injuncted. This is dangerous. In fact, the appellant also reached out to creditors and all the business associates of the firm, my lord. And all this because of some internal dispute, my lord. Ultimately, the welfare of the firm is of paramount importance.
Yes, anything in response?
Maintainability, of course, your lordship, I'm not urging that as of now, my lord, because like I said, the judgments are not in accord. That single bench's view was Akmal Ali was dealing with a case where an interim order was granted and therefore it was maintainable. Although there's one sentence perhaps which says that refusing will may also be appealed against. My lord. So these are that area, of course, is a little gray. My lord.
Short reply, my lord. My lord, your lordship may cannot see the submission that my earlier suit bars the present suit, my lord. Lordship may cannot to see page number 190, my lord. In earlier suit, my lord, reliefs are different. Comprehensive relief has been sought in respect of all the firms and business entities, my lord. And based on different causes of action, page 190, my lord. This is earlier suit by the present appellant number 1 and others.
190.
190, my lord. These are based on cause of action of 4/11/19, 7/11/19 onwards till February 2025 and 26/3/25, my lord. This suit was filed seeking relief, comprehensive relief against all the partnership firms and business entities, my lord. Now, lordship may kindly to see page number 248. The present suit is based on different cause of action against different persons, my lord. Page 248, my lord. So section 10 is not attractable in respect of present proceeding, my lord. Furthermore, the existence of arbitration clause is also not a bar in respect of the present suit because the lordship may cannot see in this suit. All the parties to this suit, my lord, are not the signatories of the deed of partnership, my lord. Who? All the parties to this suit, my lord. Has my lord, arbitration proceeding, arbitration clause is not invocable in respect of the present subject matter in dispute, my lord. And my lord, this issue is already.
Who are the present petitioners?
My lord, this issue is already the subjudice in the earlier suit, TS 266, my lord, wherein Section 8 application has been filed. That issue is yet to be decided.
No, whether you are a signatory to the partnership agreement, whether arbitration clause is there.
Well, arbitration clause is there, my lord. Arbitration clause is there, my lord.
Suits may be against various persons, but
My lord.
this suit is between you, between the signatories of the partnership agreement.
Partnership deed, my lord. One more submission, my lord, regarding the maintainability of this appeal, my lord. I am relying upon the judgment of the full bench of this honorable court, my lord, in Akmal Ali, my lord, reported 1984-10-133, my lord, in paragraph 8, my lord. This has been laid down by this full bench of this honorable court, my lord, that any order passed under Order 39, Rules 1 and 2 are appealable, my lord. Any order, whether granting or refusing injunction, my lord. So this is, my lord, not correct that this appeal is not maintainable in view of refusal of grant of injunction, my lord. Para 8. These are submissions, my lord.
Pass out this.
Look, your lordships with the other judgments which deal with the scope of an appeal, perhaps that will not be necessary.
Necessary at least today. Yes.
Deeply obliged. Much obliged.
Is wait for a adjournment.
Number 1 and 2.
On the prayer of
Not
learned
today.
counsel for
Come to report.
respondent number 1.
1 and 2, no?
1 and 2.
The matter again on
Obliged, Lord.
Obliged.
Court jump.